Hello and welcome to our Week 2 lecture covering confidentiality for the behavior analyst. Going to be covering HIPAA, FERPA, and the ethical code. My goal is, for this presentation, is to give a broad overview of confidentiality and how that applies to your practicum site and your future employment site and your career and role as a BCBA in either the healthcare provision system or the education system. Confidentiality is something that is just often taken for granted in the sense of very often when you get to a new organization and you go through the onboarding intake process, confidentiality is something that's kind of glossed over, like, oh, everybody knows this, we can't disclose this and this, and kind of move on without really spending a lot of time talking about the why or the underlying laws and regulations for that. But there are some very important kind of fine-grained details that you need to know, and we'll touch on some of those and give you some resources that have much more detail than I could give in this presentation. So regardless of where you work, whether it's in a healthcare side or the education side, or the organization behavior management side, working in private businesses, all behavior analysts are subject to the Code of Ethical Conduct. So that's going to be the main focus of this. But then also you may fall under HIPAA, the Health Insurance Portability and Accountability Act, or FERPA, the Family Educational Rights and Privacy Act. Most ABA programs, as I said, do not cover the details of these acts, these laws, which can lead to unintentional violations. I know my BCBA training program, we spent very little time getting into the actual practice of confidentiality. Glossed over the ethical code, but didn't get into the details of it. So I hope to go into a little more detail than most programs are able to go into. So the Professional and Ethical Compliance Code, which I refer to throughout as just the code, again, as most of you should know, although I don't want to take it for granted because this is the first time I've mentioned it in this course, the Professional and Ethical Compliance Code for Behavior Analysts applies to all individuals who are an RBT, a BCABA, a BCBA, or working and supervised by a BCBA. So there's 10 parts to this code. The part that we'll be covering is 2.0, which is responsibility to clients. Okay, so section 2.06, maintaining confidentiality, and the black text here is taken directly from the compliance code, and the blue are my additions to that. So it states that behavior analysts have a primary obligation to take reasonable precautions to protect the confidentialities of those with whom they work or consult, recognizing that confidentiality may be established by law, organizational rules, or professional or scientific relationships. So it's saying that you always have to maintain confidentiality, but there are other more specific regulations that you need to follow. Other laws that have more restrictions in the code. The code is just kind of a basic minimum. Okay, this goes on in section B to say that behavior analysts discuss confidentiality at the outset of the relationship and thereafter as circumstances may warrant. So this is a really important thing to talk about as soon as you meet with a new client. First thing, before they start telling you about their problems and this, you want to help them understand their rights of confidentiality, but even more important, its limits. This can prevent complaints and misunderstandings, and we'll talk more about some of those limits, but if there's certain things that you hear, you may be obligated to report, and if there are certain instances in which you do share information, such as with your supervisor or a billing agency. Okay, section C states that in order to minimize intrusions on privacy, behavior analysts include only information germane to the purpose for which the communication is made. So oftentimes it's ethically allowable to share information by a client in certain circumstances, such as conferring with your supervisor on a difficult case or a colleague. But in these circumstances, avoid sharing more information than is directly necessary. For example, and I see this all the time, if somebody goes and ask a colleague for their advice on a situation, you really only need to give the basics of the behavior to get their advice on what sort of data collection method or intervention is necessary. But what happens is often they start to share this information and they go in, but oh my gosh, this family is this and this, and oh, you won't believe what they did the other day, and can you believe that they live here and do this, and his father works here, and all of that is very interesting, and I completely understand the temptation to share that with colleagues, but it is unethical if it's not directly related to the purpose of the communication. So if you are communicating to figure out, for example, which data collection method would be best, if you should use a partial interval or whole interval for a behavior, going into all the other information about family and history and all of that is unnecessary and therefore unethical. Code 2.06 goes on in section D to state that behavior analysts discuss confidential information or evaluative data concerning clients only for appropriate or scientific purposes and only with persons clearly concerned with such matters. So this is very important because it states that there are circumstances in which confidential information may be shared, but it is on a need-to-know basis, as stated previously. So if you are sharing information with a colleague to transition a client, do not do so in front of other colleagues who are not directly involved. And if you need information from a specific colleague about treatment for, let's say, something very specific like eating disorders or feeding protocols, then doing so, sharing a client information in front of the entire organization at a whole team meeting would not be appropriate, because then you're disclosing information more than is necessary to make progress on the case. Okay, and section E states that behavior analysts must not share or create situations likely to result in the sharing of any identifying information, written, photographic, or video, about current clients and supervisees within social media context. So this is the big one when we talk about confidentiality these days. The hot topic is social media disclosures. So there are very few instances when a practitioner will look back on a situation and say, boy, I wish I would have shared more on social media. That I can't think of a situation in which a clinician would go back with that mindset. It's almost always the opposite of, ooh, I think I overshared on social media. And sometimes it can be quite serious, involving losing your certification, licensure, getting sued. So to be safe, keep all client information or mention of clients away from social media. Be very careful about creating videos and photos. Once electronic files are created and shared, you lose control of their use. So if you maybe just PM a picture to a colleague or friend or somebody, just one person is safe. Once you send that, it's gone, it's out of your control. Then they can share it with the world if they want. And then you have, according to this, created situation likely to result in the sharing of identifiable information, such as photographic or video. And also, if your account or the account of a colleague is breached, hacked, or compromised in any way, it could result in all of your electronic files being accessible on the internet forever. And that's one of those things. Once it's out there, there's no just grabbing it and taking it back. There's nothing really ever goes away on the internet. So takeaway is, they said you'll never regret having too much confidentiality in regards to social media. The safest rule is just keep all things off of social media completely. And anytime you send out any file, you are throwing it out there and relying on the trust of someone. For instance, if you share it with one colleague, let's say a funny video of a client, share it with a colleague, you trust them, all this. Well, if they share it with one more colleague who they trust but you don't know as well, and then they share it with a couple of theirs, it can clearly get out of hand pretty quick. And next thing you know, you could be seeing it on YouTube. The ethical code goes on in 2.07 to pertain to confidentiality in the area of maintaining records. So Section A states that behavior analysts maintain appropriate confidentiality in creating, storing, accessing, transferring, and disposing of records under their control, whether these are written, automated, electronic, or any other medium. So to me, this means, appropriate confidentiality means use common sense. Don't leave client documents sitting out on your desk, on your coffee table at home, or sitting out in your car. There are other examples that I think are a little more unexpected that don't leap to mind immediately. And a lot of these come from experience with me. For example, if I'm giving a presentation to colleagues, I often use my computer, and I'm almost always signed into email. Well, I've given presentations, and then my email alerts pop up, and then go projected onto a screen in front of many, many people that might say, alert SC at this school is having a bad day or something, and that information, even though it just had initials, most of my colleagues, if it's initials in school, could put together that so-and-so is having a bad day, and then that's some confidential information that was thereby disclosed. So if people are looking at your computer screen, be sure to disable the email alerts that pop up with the subject and sender. Also, electronic calendar entries. A lot of organizations have the feature where you can see each other's calendar. So if you just be careful how you label events without much client information or details. I have here, it's training Johnny Smith's team on restraint training. Well, then you've disclosed to anybody who can see your calendar that Johnny Smith is needing restraints, and that's something that the team is working towards, which could very easily get back to the family and other people who may not necessarily need to know that information. And always have a passcode on your electronic devices. So if you get your work email on your phone, you need to have a passcode on your phone. I think most people do, but I know some people who don't, and anybody who grabs that has access to tons of confidential information. And I also know a lot of people are pretty lax on locking file cabinets and drawers, but it's pretty inexcusable if someone were to come in and get at that. If you didn't have it locked, then you are liable for that information escaping. Okay, the next section of 2.07, behavior analysts maintain and dispose of records in accordance with applicable laws in a manner that permits compliance with the requirements of this code. So when you're disposing of things, make sure that they are shredded or given to someone who does shred it, a licensed, I think it's called document destruction contractor or document disposal contractor. And do not keep sensitive client documents in a typical webmail program or shared organization drive. So if you have at my school district, we have an H drive that put that in, but anybody can get into that H drive. So be careful what you have in there. Okay. Now going on to code 2.08, this is about disclosures. So this states that behavior analysts never disclose confidential information without the consent of the client, except as mandated by law or permitted by law for a valid purpose. Okay, so we're going to talk about both of these later on, when it's mandated by law and when it's permitted by law. So these 1 through 4 here are instances where disclosing confidential information is permitted by law for a valid purpose. So one is providing needed professional services. So if you need to confer with a speech language pathologist, for instance, about some articulation issue. Number 2, obtain appropriate professional consultations, and that's really same as a previous example in this case. 3, protect the client or others from harm. So that is if you learn about abuse or neglect, and actually that is not just permitted by law, but that is actually mandated by law. We'll talk about that a little later. Or to obtain payment for services. So anytime you're billing, or you're either billing an insurance agency or the state or if for your employer you have to, code your time with specific clients, that is all valid purpose permitted by law. So behavior analysts recognize that parameters of consent for disclosure should be acquired at the outset of relationships. So all these examples are exactly what you go over with clients at the beginning. You say, like, I will keep everything confidential, except there are times when I won't. So when I need to consult with someone, when I need to, if you're training an RBT, for example, obviously you will be disclosing personal information. And when it's billing, you have to disclose there. Typically, the rule that I have here in blue is disclosure of confidential information is typically allowed if it's necessary to provide services in the best interest of the client. If you keep that in mind, if it's necessary to provide services, then you're probably okay. But again, these situations should be discussed at the onset or outset of supervision and documented with a privacy policy acknowledgement form from your organization. Most organizations have that, and certainly school districts and larger ones do, but make sure that you are aware of that and you go through it with the client and not just gloss over it and have them sign it. Okay, and I want to take a closer look at number 3 in that previous 2.08, protect the client or others from harm. So although situations may vary by state and locality, generally you must disclose personal information in circumstances in which the client is in imminent danger of harm to self or others. So if the client is going to be hurt, their safety is in jeopardy, or if the client is putting the safety of others in jeopardy, you need to disclose that. Okay, and the applicable law here, and I learned quite a bit about this when I was doing this presentation, is called duty to warn laws. This comes out of the 1970s when a therapist was sued for not reporting threats his client made regarding murdering his wife before he did eventually murder her. So a client was working with his husband and he said several times in sessions, I think I'm going to kill her, I think I'm going to kill her. The therapist believed they were working through that, did not report it to anyone, and then he went through with it, and he did actually kill his wife. And the wife's family ultimately sued the therapist. The therapist said that, he was just protecting confidentiality. He wasn't allowed to, but the court ruled that there is a duty to warn. So now there are many laws in states requiring therapists and medical doctors, psychologists, psychiatrists, etc. to warn potential victims if threats are made in a session where imminent harm of danger exists. It's also known as the Tarasoff law, I believe that was the victim's last name, or the duty to warn law. Some states don't have these provisions for healthcare providers, so you need to be familiar with what is the duty to warn law, or lack thereof, in your state in which you practice. So since we're studying in Missouri, I do want to go a little more into detail about what that looks like here in Missouri, but again, other states vary. So there's a resource posted to this week's resources and files in Moodle. It's called the Missouri Department of Mental Health Regulation 4.410. So it's a pretty detailed document. I'll just go over the main points. But basically, anyone who's a mental health coordinator, which does include behavior analysts in some instances, are required to take action if they believe there is a risk of physical harm to others. Now, of course, there's no way to clearly objectively measure that or quantify that. But if you believe there's a risk, you're probably better off reporting it than not reporting it. If, again, you believe it's a risk, if it's not totally, if a client says that he's going to fly to Venus to get a laser gun to come back and shoot his sister and the kiddo's 8 years old, there's probably not as much of a risk of them actually doing it. If it is a high-functioning adult who says that his ex-girlfriend who's cheating on him deserves to be stabbed and we know he has a history of violent behavior, then I would say that there's definitely a risk of physical harm to others. So the action involves you contacting the director of the facility or organization, which could be you, but contacting who that is, and then the regulation specifically outlines what information can be shared. The important part is that you go to your supervisor with that information, make sure the supervisor is aware of the regulations, and then go from there. Okay, so the other instance in which it is allowable to disclose personally identifiable information, in this case actually mandated, is for mandated reporters. So in some cases you are legally required to disclose confidential information if you have reason to suspect abuse or neglect of a child. So professionals who are subject to this regulation are referred to as mandated reporters. This varies by state. I do want to go into a little bit of detail about Missouri because that's going to apply to most people in this course. So I have attached, again on the course documents in Moodle, Missouri Department of Social Services guidelines for mandated reporters of abuse and neglect. So this is a really helpful resource for when to report signs of abuse and neglect and what that process is. I really recommend that everyone ask their practicum site supervisor if you are a mandated reporter. And all school personnel are mandated reporters in Missouri. So if you work for a school, I can tell you right now you're a mandated reporter. There definitely are other instances in which you may be a mandated reporter, but you should ask your site supervisor. Okay, so we've talked about the code for behavior analysts that applies to everybody. And the two other laws that apply to some or most of you are HIPAA and FERPA. HIPAA we'll talk about first. That is the Health Insurance Portability and Accountability Act. So even those who are not directly healthcare and aren't necessarily legally required to follow HIPAA would do well to follow its guidelines because they provide an additional level of confidentiality protection. So some of the aspects of HIPAA that may not apply to everyone depending on where you work, but are a good idea to use anyway, are using encrypted email when transferring any client information. Regular email is often not compliant with HIPAA. Now, a lot of times schools, and I have this situation a lot when I work in my school position, we are not subject and do not follow HIPAA email guidelines, but some of the people with which I work, such as outside speech therapists, for example, do use HIPAA. So you need to be familiar with those guidelines because even if you're not working in a organization that follows HIPAA, you will be working with people who follow HIPAA. Also, if you're doing any sort of video streaming, you need to use one that's HIPAA compliant. VC is one of them that's HIPAA compliant. Skype typically is not, although I hear different opinions on that and I don't know 100% sure, but that is what I'm told quite a bit in a lot of organizations within which I work use VC and not Skype. So also another one that is mentioned in the HIPAA literature is not to identify client name in the subject of an email. Use either initials or nothing at all, just say mutual client discussion, something like that. Okay, the other laws that may govern your confidentiality practice are FERPA and IDEA. FERPA is Family and Educational Rights and Privacy Act, and IDEA is Individuals with Disability and Education Act. So it's similar to HIPAA in that it covers all personally identifiable information from disclosure without permission, and there are some exceptions such as reporting to the state for compliance, or again the mandated reporter or duty to warn. So most people are going to fall either into the health field with HIPAA or the education field with FERPA, and it's good to know more details about those. But the main takeaway from this lecture is to be familiar with the ethical code, and if you stay in compliance with that and know the specific stipulations of the other governing laws, then you will maintain confidentiality and protect your career as a behavior analyst and the privacy of your clients. Okay, well, thank you very much for sticking with me. I know confidentiality isn't always the most exciting topic, but it's very important. It's one of those things that doesn't matter until it does matter. People don't take it too seriously until there's a complaint or a breach, and then you're scrambling to figure out exactly what the regulations are. So It's best to be familiar ahead of time. You have any questions, please feel free to reach out to me. Thank you very much, and I will have another lecture for you next week.